lethal use.
Your whole point was that Congress didn't speak clearly enough here, but C1D2, as you know, because amicus emphasizes it, I mean, I don't know how that could be clearer. No term of imprisonment imposed on a person under this subsection shall run concurrently with any other term of imprisonment imposed on the person. I mean, that's very clear, and it starts with notwithstanding any other provision of law in D. Notwithstanding any other provision of law, no term of imprisonment imposed shall run concurrently.
Indeed, Your Honor. So the operative language to activate this section is that a term of imprisonment has to be imposed under this subsection. That is the question here. May a term of imprisonment be imposed under C if someone is punished under J for the same offense? That's the question here. And as to that question, C1D2 is silent. It doesn't address it. And as the court has explained, silence cannot be a clear indication to double punish.
And what would be necessary, do you think, to make that clear?
What would be necessary would be something like what appears elsewhere in the statute. We have two examples in 924C of where Congress has ordered multiple punishments. One, it said if you possess a gun, you get a punishment for that in addition to the underlying crime of violence. It's also in C5 said if you use a gun loaded with armor-piercing ammunition to kill, you're getting a lot of punishments.
C5 came in much later. I mean, this was in 71, right? 924. C1D2 came in?
Yes, and even when it came in, Your Honor, in Simpson and Busick, this language was in the statute. And this court said in Simpson and Busick that this language, requiring a minimum, requiring it to be consecutive, was not sufficient to constitute a clear indication. That's why Congress had to amend the statute to make it crystal clear that it wanted to double punish both possession.
You want it to be in both 924J and in 924C, the provision that it can't be concurrent.
No, Your Honor. There is no provision in either of these statutes addressing this scenario here.
And is that because you are distinguishing two convictions versus two punishments? In other words, it seems to me that this provision that Justice Kavanaugh is pointing to is about whether you can run the sentences that have been validly determined relative to two separate convictions, whether you can run those or have to run those concurrently. But your question is, can we have two separate convictions under these circumstances?
Precisely, Your Honor.
Right. So that's why this doesn't have anything to do with that.
Precisely,
the question that's at issue with this, under double jeopardy, it's can we have two separate convictions for the same offense, for the same conduct, not whether the sentences that flow from those two separate convictions can be run concurrently or
well, I thought we
consecutively or whatever.
Sorry.
Yeah.
Well, I thought we talked about that in oral argument in Laura. We foresaw, I think, exactly what was going to happen at the oral argument in Laura about this.
Well, Justice Jackson, you're absolutely right. We don't get to sentencing unless there's a valid constitutional conviction imposed. That is the question in this case. Can someone be convicted under C1 and also J for the same crime? And nothing.
So can you